Hi folks, and welcome back to Contract Law. This is video 2 in the video series on discharge of a contract. And in the first video series we had a little look at the preliminaries, bit of groundwork, and we started to look at discharge by performance. And in particular we looked at when performance was satisfactory and when performance as to a time stipulation was not satisfactory. And then we asked ourselves what happens when the failure in performance doesn't have to do with time. The place to start this discussion is with the general proposition that performance of your contractual obligations has to be complete and exact. You have to deliver whatever it is that you promised to deliver so that the other party gets what they bargained for, which makes sense, doesn't it? If the other party doesn't actually perform how they've said that they would perform, then there's going to be a breach and you'll be able to sue for damages, or you might even be able to terminate the contract. But I guess the big question for the other party that's fallen short in their performance is whether or not they can get paid. And here there are a number of different aspects of the party's obligations and the party's performance that you need to look at to work out if your client is the one that's fallen short, whether they can actually be paid. The first thing that you need to look at is the nature of the party's obligation to pay. The next thing you need to look at is the contract itself. The last thing you need to look at is how exactly the party has performed and whether it might be substantial enough to get paid. Okay, looking first at the nature of the party's obligation to pay. This is just an assessment that you'll make at the beginning of the exercise in trying to work out whether or not your client can get paid despite some kind of defect in performance. You need to look at the contract and determine whether the party's obligation to pay the contract price is independent or dependent. Now, if you're acting for the client whose performance has fallen short and you find that the party's obligations are independent, happy times, because what that means is that one party must perform regardless of whether the other party does so. For example, in a contract for sale of goods, one party promises to pay on a set date, and that obligation is independent of the other party's obligation to deliver. So that party's going to have to pay on that date regardless of what the other party does. So if you're acting for the non-performing party, happy times, if obligations are independent, you can ask for performance without your client having performed their own obligations. You certainly don't see these very often anymore. They were a little more common in days of yore, not so much nowadays. Quite rare, in fact. Most usually you will see that the party's obligations are dependent. Vast bulk of contractual obligations are of this nature. So performance by one party depends on performance by the other party. So in the usual contract for the sale of goods, the buyer doesn't actually have to pay until not only the seller has delivered the goods, but the buyer has actually accepted the goods. Works the same way in employment contracts in particular. So it's often said that the consideration for work is to pay wages, and the consideration for wages is to deliver the work. The parties' obligations are mutual and dependent. Here we have the lovely case of automatic fire sprinklers in Watson. This was a 1946 case just after the Second World War. And I think of poor old Mr. Watson as a lovely little old chap with one of those leather-bound briefcases. What had happened to poor Mr. Watson is that the company wasn't terribly pleased with his performance at automatic fire sprinklers. And so they purported to, well, there was some complicating legislation, but in essence what the company did was they demoted Mr. Watson from his position as general manager to a position as mere manager. And Mr. Watson really wasn't terribly happy with that. when the wartime legislation was lifted, the company purported to terminate Mr. Watson's employment, and dear old Mr. Watson wasn't very happy about that at all. And what he proceeded to do was turn up with his little briefcase to the company for almost a year and continued to do his employment duties until the company got so sick of Mr. Watson that they decided to actually physically exclude him from the premises. In that case, it was said that even where you've got a wrongful dismissal, you can't just keep turning up to work and showing that you're ready, willing and able to actually do the work. You have to be doing the work under a contract, and the contract will have mutual and dependent obligations. So where you have a wrongful dismissal issue like that, you can't just refuse to accept the dismissal. You have to resort to your other remedies, which are an action for wrongful dismissal and damaging. So that is the issue of dependent obligations. The next thing to work out for your client that has underperformed is whether the contract is entire or divisible, and this is the big ticket item here. If your client finds themselves locked into an entire contract, it means that the contract price is only payable in exchange for exact performance of the whole contract. Nothing less will do. Courts generally don't like to interpret a contract as being entire, and they'll normally demand these two conditions be present somewhere in the factual matrix. The contract itself will normally specify that complete exact performance is a condition precedent to payment. The second thing is that the benefit expected by the defendant results from enjoyment of every part of the work jointly. The benefit expected results from every part of the work jointly. Consideration can't be apportioned to part of the work. So the usual typical example is if you have a contract to have a pair of shoes made, and the shoemaker delivers one shoe to you, that's really not going to do you much good, unless perhaps you're going to a fancy dress party for one shoe people. So in that kind of circumstance, the contract would be entire. One of the early and very unfortunate cases of the entire contract being found was Curran Powell. It was a 1795 case, and in that case, poor old Mr. Cutter signed on as a sailor on a ship sailing from Jamaica. I think it was an 8-week journey. And in that particular contract, that he signed up to, it stated that he was going to be paid 30 guineas for his services, provided he continues and does his duties to the port of Liverpool, provided that. So you can see very clearly performance is a condition precedent. The other thing that swayed the court in this particular circumstance was that the ship owner had paid very dearly for this entire performance, far more than the market going rate for services of this nature. Unfortunately, Mr. Cutter died 6 weeks into the 8-week journey, and when his executors sued, unfortunately, Powell was able to resist payment of any part of the sailor's wages because the contract had been an entire one. So you can see very clear potential for injustice in those kinds of circumstances. And normally, a court will not interpret a contract as entire. It will be interpreted as divisible. And divisible contracts are far easier to claim upon for some payment where there has been less than complete and exact performance. In divisible contracts, both the consideration and payment for it, that is the work to be done, can be apportioned according to the work to be done. So the contract itself will normally be severable, and that's why they sometimes call these contracts severable contracts, into separate little compartments where you can kind of work out what the consideration is for each part, each divisible or severable part of that contract. So if we had a contract for the sale of goods to deliver 1,000 carburetors at $10 each, 350 by end of June, 350 by end of August, 300 by the end of September, you can say that there's 3 severable parts. So you can work out there, if you had that contract and it was only performed for June and August, you'd know exactly what the underperforming party could claim for. So perhaps a fairer interpretation of contractual obligations. Steele and Tardiani is just a good example of that. This was a wartime case where some enemy aliens had been interned and they were released to perform some timber felling for a particular landowner. The contract stipulated that the lengths of timber were to be cut 6 foot long and 6 inches in diameter. There was a dispute about the work that was done. The landowner tried to avoid all payment for the timber that was felled, and these enemy aliens decided to ask for payment for the work that did conform to the contracts. So it was something like 6 shillings per length of timber cut to 6 inches in diameter. So they asked for the contract to be construed as divisible and to be paid for that much of the work that had been done according to the contract terms. And in fact, the landowner had accepted all of the contract of wood that had been cut for him. So the enemy aliens also sued under what we call a quantum merit. We'll look at that later when we're talking about remedies. But they also sued for a fair price to be paid under the quantum merit doctrine for the rest of the timber that had been accepted, and they were successful. So that is the issue of divisible contracts. Usually a court will try and construe a contract as divisible if some work has been done and the contract does allow you to work out how to pay for what has been done. The difficulty really is where there's a lump sum payment for a specific amount of work, like one task, and you can't divide that up easily. Some commentators have proposed that these contracts be called a lump sum contract. That is, it's a sum that is paid a specific amount for a specific task, but they are not to be construed as entire contracts. Now, if you have this kind of situation, then because complete and exact performance wouldn't be a condition precedent to payment, if there had been substantial performance of a lump sum contract, then the underperforming party could ask the court for some payment. And that's where we're going right now. That is the issue of substantial performance. So this doctrine applies where the contract, as I just said, is not entire. The obligation to pay is not independent. So you don't have that kind of get out of jail free card, which would allow an underperforming party to still demand for payment of their price on time. Also, the problem must be more than just de minimis, because if the underperforming party's defect in their work is just de minimis, that is so small as to be trifling or inconsequential, the court's just going to disregard that underperformance. So the deficiency is more than de minimis, then what you have to work out is whether the performance has been substantial enough to get paid. Usually, if there has been substantial performance, what you can claim for is not complete payment of the contract price, but payment of the contract price less a set off for the amount that it's going to cost the other party to fix up your faulty or your client's faulty performance. And here we have two good little bookend cases that show the outer edges of this doctrine very clearly. Everything else in the middle is kind of grey, but these two form good bookends to show you the polar edges of this doctrine. So the first is a lovely Lord Denning case called Hennik and Isaacs. In that case, there was a contract to furnish a flat, renovate a flat, and that contract was for £750. Payment being net cash as the work proceeds and the balance on completion. So clearly there were progress payments, but the payment was for all of the work to be done. The work got started, £400 had been paid. The work was then completed, but not to the contracting party's satisfaction. So one door of a wardrobe had to be replaced and one bookshelf was too short. The cost to fix all of that up was about £55. So what happened there? Could the underperforming party claim the rest of the £350? Yes, Lord Denning said absolutely yes. Less was set off for the £55 that it cost to fix up that workmanship. The other end of things is BoltonMardiva, and in that case you can kind of see why this is the polar opposite of Hennik and Isaacs. This was a contract to supply and install a water heating system, £560 worth. It was installed, but when it was installed, it was turned on and then the house would flood with noxious fumes, and the thing didn't actually work properly to boot. So the contracting party there certainly wasn't very happy with what they got. The plaintiff, perhaps surprisingly, claimed payment. Lord Justice Cairns said you've got to look at the nature of the defects and the proportion between rectifying the defaulty workmanship and the contract price. Here it was about a 31% differential, £174 it cost to fix. Out of £560, that's quite substantial, isn't it? So basically in that case there was held no substantial performance, and therefore the underperforming party got nothing. Okay, no substantial performance means you get nothing. So they're the outer edges. If you look at rules of thumb, you've got the Hennik and Isaacs situation on one hand. Defect is minor, rectification cost less than 10%. In Hennik, it was £55 out of £750. I think that's about 7%. So the court's probably going to allow recovery, less a set off. If the defect is major, like in BoltonMardiva, probably not going to allow recovery of anything. The more difficult questions are, as I said, in between. If the defect is minor but it costs more than 10%, you might get recovery if the rectification costs would be reasonable, more than 10% but still reasonable. If the defect is major but the cost of rectification is small, very, very hard to say in that circumstance. If the defendant could actually go ahead and terminate for the defect, then there's probably not going to be any recovery allowed. So they are the rules of thumb there. As I said, if you've only partly performed, generally you'll hear a court say things like the work is no value to the defendant, the work's entirely different from what was bargained for, or that the plaintiff actually repudiates or abandons the contract by their very shoddy performance. So one stellar example of this was coroners statement, and in that case we had a contract to erect a fence. The fence posts were to be 12 feet apart. What was constructed was some posts 12 feet apart, some as far as 18 feet apart, so half as much again apart. As you can tell, on a large property, that's not going to be terribly satisfactory. It could be fixed up with star droppers, but the cost to fix was half as much again as the original contract price. In that case, no substantial performance. Fence and posts 12 to 18 feet apart was entirely different to what was asked for. No recovery of any money at all. So something like the BoltonMardiva kind of scenario there. That is the issue of substantial performance. If all that doesn't work, and if the plaintiff can't claim the contract price, there are a number of other escape routes that might persist. They might be able to file a claim in damages. They might be able to make a claim of quantum merit, like I said in Steele and Tardiani. they might be able to make a new agreement to abandon the original contract and agree to the lesser performance. We'll be talking about variations in the next video. You might also find your clients excused from performance if there's other intervening factors, like the other party has somehow obstructed their performance, so either prevented them from performing entirely, or your client has actually performed but they've refused to accept the performance. So all of that is discharge by performance, and now we need to look at discharge by agreement. But we have passed our magical 15-minute mark, so I'll end this video here, folks, and I'll go across to video 3. So I'll see you then. Bye for now.